Welcome to InstaLegal. Consumer rights have started gaining momentum, and even the government undertaking, such as railways, are also covered if a person falls in the definition of consumer as provided under the Consumer Protection Act. Recently, this act was amended to protect the rights of consumer from even e-commerce where there is a deficiency in service. Today's discussion is on the recent decision of Supreme Court which made railways liable to pay compensation for deficiency in service. Is railways liable to pay compensation for late arrival of train was the main issue which was faced before the Honorable Supreme Court. Let us see the main facts of this case. The facts were that the complainant had booked four tickets. The complainant had booked 4 tickets on Ajmer Jammu Express train with boarding at Alwar. However, the train reached with a delay of around 4 hours, because of which the complainant missed his flight from Jammu to Srinagar and he had to avail a private taxi. Due to late arrival at Srinagar, loss was suffered as houseboat was pre-booked. Now, thus, the consumer complaint claimed deficiency in service and filed a case before the Alwar District Consumer Forum. The main issue which the forum had to decide was whether late running of trains could be said to be deficiency in service on the part of the railways. The contention of the appellant, that is the railway, was admittedly the train arrived late at the destination, but it was contended at all the consumer forums, that is before the Learned District Forum, before the State Commission and before the National Consumer Forum, that the railways never guarantee any arrival and departure on timings of the trains. It also argued that the late arrival of train cannot come under the ambit of deficiency of service, specifically in view of Rule 114 and 115 of Indian Railway Conference Association Coaching Tariff number 26 Part 1, whereby the disclaimer is provided and hence railways shall not be liable for any compensation for late running of the train. This contention, however, was not accepted by neither the District Forum, neither the State Commission, and it was upheld even by the National Consumer Forum. The decision of the Supreme Court basically revolved around the fact that there was no evidence which was put up by the railway authorities to explain the delay. Court observed that admittedly the train reached the destination 4 hours late, which led to complainant missing his pre-booked flight and lost his booking for the boat in Dal Lake as well. However, no evidence was produced by the railways to contradict or explain the late arrival of train to prove that the delay occurred beyond their control. The court stated, and I quote, "Therefore, unless and until the evidence is led explaining the delay and it is established and proved that delay occurred which was beyond their control or even there was some justification for delay, the railway is liable to pay the compensation for delay and late arrival of trains." It further observed that in absence of any evidence led to explain the delay, this amounts to deficiency in service, and therefore the award passed by the Learned District Forum, Learned Commission and Honorable National Commission making the railway liable to pay the compensation to the complainant passenger was upheld. The special leave petition was in this case dismissed. In all circumstances, the delay in arrival or departure may amount to deficiency in service. However, where the railways made no attempt whatsoever to explain the delay that took place, delay without any reasonable explanation is certainly a deficiency in service and the award of compensation is justified. The consumers now have to understand that whoever is a service provider and there is any kind of a deficiency which can be covered under the Consumer Protection Act, compensation for the same can be granted for the harassment that has been caused due to the deficiency in service. Thank you very much.